Thank you.
Lord Alton.
Thank you. Dame Sara, it's a rare opportunity to say thank you for all the work that you did, and indeed that Kevin Hyland did as Commissioner before you. I've noticed, I've just stepped back from being a trustee of an anti-trafficking modern slavery charity, and I was very struck by the protections which the modern slavery legislation gave and the presumptions that it made as well. And I'd like to take you on to the illegal migration bill on issues like truthfulness. I mean, it's quite difficult for someone who's escaping a country where there's massive persecution to be able to truthfully tell the circumstances, and so often there will be false accounts. Will the presumptions be changed now in the illegal migration bill so that if someone tells a story that wasn't true, how will that affect their right to stay in the UK?
I think the proposals in sections 21 to 28, as colleagues have said, just, have a devastating impact on the protections, the modern slavery protections that we have. So section 21 says that if somebody meets the condition for removal under section 2 and has a positive reasonable grounds decision, then any prohibition on their removal or any leave to remain doesn't apply unless they're cooperating with an investigation or criminal proceedings. The bill proposes that public order disqualification in the National and Borders Act, which I just referred to, is automatically applied to an illegal migrant to whom the Secretary of State has said is required to remove. That is a massive extension of that public order disqualification to everybody. And Section 22 says, again, if they meet the conditions for removal and have a positive reasonable grounds decision, then any requirement for support and assistance doesn't apply either. So the whole framework of modern slavery protections do not apply if somebody is an illegal migrant after the 7th of March. So it basically denies those who are trafficked to this country and arrive irregularly any modern slavery protections. It in effect suspends them it suspends protections in a way for anybody who's not British. It's for a 2-year period, you might have noticed. It has a sunset provision, and I do wonder whether the use of the sunset provision does suggest that the Home Office realise that this is a pretty severe measure that they are proposing, because what we're proposing is that we are abandoning victims of the most serious crime, frankly, because they're not British. And it'll be the victims that are punished, not those that are trafficking them. As was said earlier, this is the sort of thing that enables traffickers to tighten their grip even more on victims. And there is that exception that if people are cooperating with an investigation or criminal proceedings, that they won't apply. But it seemed to me that the caveats about the Secretary of State believing that it was absolutely necessary that they remained in the country, it seemed to set the bar quite high. But I also think it fails to appreciate the trauma, the lack of trust and confidence that victims will have. And I suspect the exception will be little used. Very concerned. And in terms of this particular committee, it seems to me that it cannot be compatible with Article 4, with the state's positive duty to identify and support victims of trafficking, irrespective of where the exploitation occurred, and I think that's really important. That's quite clear in Article 4, and nor is it compatible with that obligation on the state to investigate potential cases of trafficking. So I think it's highly problematic. I mean, I had a quick look at the Council of Europe's latest guidelines on Article 4 and a summary of all the cases, and I'm sure that you'll be getting legal advice on that. But my reading of it is I don't see how it can be compatible with Article 4.
Thank you very much, Dame Sara. You've really rather read our minds, I think, because ECAT and the ECHR would have been my next specific question, but I think you've covered that pretty well in what you've just said. Yeah. There's just one item, though, which perhaps we could pursue a little bit further in talking about the disapplications that you've said will have a devastating impact, that it will be the victims who will be punished rather than the criminal gangs who are responsible for the misery of the people we've been talking about. But what about the recovery or the reflection period? Will the removal of that, what impact will that have on the victims of modern slavery and trafficking specifically?
So I suspect what will happen is, rather than being in one of Kathy Bettridge's safe houses, a victim will be in a detention centre for however long, and then removed if there are ever any removal agreements. I mean, it goes back to the fundamental point about this bill, which a lot of people have said, is it really workable? Where are all these thousands of people going to be detained, and to which countries are they going to be removed? But on the face of it, the practical implication for a victim of trafficking is that rather than getting the care and support as part of the Salvation Army contract, with a caseworker, with maybe legal advice, with medical care if that's needed, or counselling, somebody will be in a detention centre pending removal. Can I just say something about ECAT? Because I was mainly talking about ECHR.
Yeah.
The point, that extension of the public order definition, it's interesting because it is an ECAT disqualification, but it seems to me to go so much beyond what anybody could have anticipated when they drafted ECAT, because ECAT is about trafficking. But it's in effect saying if you've been trafficked into this country, that's a public order disqualification. So I think there's a real problem about Article 13. Article 16 of ECAT does allow for people to be removed to another country, but after the conclusive grounds decision. This is wanting to remove people after the reasonable grounds decision. And the other issue is Article 26, and we talked about non-punishment in the earlier session. But if you're detaining somebody who has been maybe tricked or coerced or compelled to come into this country illegally, you are then punishing them for an unlawful act which they were compelled to commit, which is in contravention of Article 26. So I think there's a real issue with ECAT. What's interesting is that the legislation seeks to use that public order disqualification, but in a way which I cannot imagine anybody ever anticipated.
Thank you, Dame Sarah. You heard Robin Phillips in our earlier session as well refer to the position of children and people who are underage. Is there anything perhaps you can add to what she said? She told us that 200 children had gone missing and hadn't been found, and presumably that number will be added to if some of these provisions were to be implemented. Have you got a view about that?
I've spoken publicly about my concern about the current situation where children have been placed in hotels. Several hundred have gone missing, and as you say, 200 remain missing. And I am gravely concerned that there hasn't been more of an outcry about this, because it seems to me highly likely that these children and young people will be in situations of exploitation, whether they're in cannabis farms, whether some of the young women, I'm afraid, might be in brothels, or whether they're just being kind of forced into exploitative work. That's the reality. This legislation, as I understand it, would detain children until they were 18. And then seek to deport them.
Anyway.
I would suggest that you hear from ECPAT, or one of the children's charities, who I know are gravely concerned about what's proposed.
Thank you very much indeed.
Thank you. Lord Delac.